If it pleases my lords and my lady, my name is Wanjiko Waithera for the 9th petitioner. I will take over from where my senior and colleague has left out. My lords and my lady, Article 259 of the Constitution is the bedrock of constitutional interpretation, and it requires that the Constitution shall be interpreted in a manner that promotes its purpose, values, principles, and advances the rule of law, and human rights and fundamental freedoms of the Bill of Rights. Further, it shall permit the development of the law and contribute to good governance. My lords and my lady, relying on the Court of Appeal decision of the Attorney General versus the Law Society of Kenya, 2019, the court emphasized that the principles of that in interpreting the Constitution, we have to look at the holistic interpretation of the Constitution, such that the various chapters and articles of the Constitution are read as one document and not as disjointed sections, where all provisions have to ultimately be in harmonious symphony. The Supreme Court, in the decision of the Kenya National Commission on the National Assembly should have conducted impeachment proceedings of His Excellency Rigathi Gachagua within the confines of the law, not outside of that. In light of this, the orders by your brother, Justice Mongo, calls upon this bench to determine and weigh three critical issues. One, what is to be deemed as adequate public participation? Question two, what is reasonable notice? And three, what is to be considered as qualitative and quantitative? On the first question, it is apparent that there was orchestrated, systematic exclusion in various constituencies, and some of the offices remained closed. This was not accidental, it was intentional, it was planned, it was vitiating the adequacy of the process and its outcome. Further, and this is in regard to paragraph 20 to 30, for adequacy to be implied, prior sensitization and education of the subject matter is necessary. On the contrary, no civic education was conducted. There was no material evidence accompanying the allegations. There was no opportunity provided for the Kenyan people to seek clarification on the issues raised on the form provided by the National Assembly as a template for public participation. This resulted in an obvious information bias, the danger of the process. My lords, my lady, in regard to the second question, I presume, my lords, that reason would have to be extinguished from the word for a public gazette that was issued on 5th of October 2024, and subsequently, on the same day, a public participation undertaken for it to be deemed as anything reasonable. My lords, it is the height of blatant contempt dressed as compliance. Courts
have ruled that conduct calculated to defeat the purpose of court orders amount to contempt. I refer you to paragraph 31 of written submissions in Samuel M. Mweru and others versus National Land Commission, and two others, 2020, KEHC 9233 KLR. The High Court stated that contempt proceedings vindicate the broader public interest in obedience to its orders, since disregard sullies the authority of the courts and detracts from the law. My lords, pertaining question 3, your brother went into the trouble of quoting the Supreme Court in the famous case of BAT. He was very express as in regard to what required to be done pertaining the public participation, that it left no question whatsoever to what the National Assembly was expected to do. The qualitative and quantitative aspect of the public participation. My lords, allow me not to quote the BAT case. I know it's already on your records, but I refer to it in regard to this. Would demand, 1, adequate information provided to the Kenyan people, which was not provided in this regard, and sufficiently reasonable notice issued for them to be able to participate, both of which are lacking. It is therefore my submission that on the test of the 3, the purported public participation carried out by the National Assembly falls short of reasonable and adequate. The National Assembly, my lords, cannot use Order 64.2 of the standing orders against constitutional protection of Article 10 and 118 of the Constitution of Kenya. Article 2.4 is express as to the supremacy of the Constitution in light of any other law or any other provision that is deemed to be contrary to the same. Allow me to refer you to paragraph 96 of our written submissions. And in specific, the matter in Orange Democratic Movement Party and 4 others was a Speaker of the National Assembly and 5 others, Constitutional Petition E491 of 2023 and E10 E025 of 2024 consolidated, and the rest, Your Honor. To save on time, in verbatim, the High Court held standing orders were procedural rules which guided and informed how the National Assembly should, at a minimum, conduct its business, including public participation. Standing orders did not, however, override the Constitution and were not a substitute to constitutional edit on public participation as expounded by the courts. It is therefore clear that should there be any conflict in regard to the standing orders of the National Assembly and the Constitution of Kenya is supreme. My lords, my ancestors are talking to me. My lords, paragraph 97, my lords. In Kenya National Commission on Human Rights versus Attorney General and another, 2015, 7634, the court held that the jurisdiction of the court to invalidate laws that are unconstitutional is in harmony with its duty to be the custodian of the Constitution, which promotes its supremacy at Article 2 by proclaiming at Article 2.4 that any law, including customary law, that is inconsistent with the Constitution is void to the in contravention of this Constitution is therefore to be deemed invalid. My Lords, Article 150, as read with Article 145 of the Constitution of Kenya, does not expressly limit the time within which a resolution for impeachment must be arrived at or concluded. Standing Order 64-2 therefore lacks constitutional bearing and is subject to judicial review by this esteemed bench. Its constitutionality must be examined under Articles 24, Article 165, 3D of the Constitution that gives this bench the authority and the jurisdiction to interpret the same. My Lords, it is my submission that demonstrably public participation purported to have been carried by the National Assembly is, for want of a better word, a symbolic affair. It was a display of the fallible nature of our attempt at democracy as a nation, and if the apparent manner in which it should have been conducted was clear and loud from Justice Mongo's orders, perhaps then the prevailing circumstances of a premeditated, politically instigated process, it could have fallen, or the orders of Justice Mongo could have fallen on deaf ears. With no shield under Order 64-2, the National Assembly is therefore exposed for what it exhibited as a lawmaking body that does not obey the law. This must result in an outcome that cannot stand in a constitutional democracy governed by the rule of law. Allow me to refer you to paragraph 33 of our submissions in the matter of Mark Foy versus United Africa Company Limited, 1961, 3 ER 1169. The very famous Lord Denning, who was as classic as the good professor of law, Gideon Wigai, held that if an act is void but incurably bad, you cannot put something or nothing and expect it to stay there. It will collapse. Any subsequent actions undertaken by the National Assembly based on the null and void acts of the purported public participation must therefore collapse. They cannot hold in law. Blatant disobedience of the court orders must be rendered null and void ab initio. My lords, my lady, I think I've kept my time. As the Latin maxim goes, fiat justitia ruat caelum, and for the benefit of our lay friends, let justice be done though the heavens fall. My lords, I will not proceed beyond that. And, you know, the good Senator Agenda was muttering something when I said that I have my sisters, my learned sisters here. Yes, they're my sisters, Senator, but they're not available. Thank you, my lord. I hand over to my colleague, Mr. Muge.
Thank you. You are smart on time.
Did you know that malaria is a top 10 cause of death in Kenya, with over 10,000 Kenyans dying every year from malaria? And the reason being a mosquito. We believe protection and prevention is the best cure in the fight to end malaria. Mortein Doom, with its trusted formulation. It provides protection in seconds. So spread the Motindu message of how we, you and I, can fight to end malaria.
Motindu, Kenya's #1 choice.
Okay.
So, my lords and my lady, I proceed after my learned colleague, Ms. Minor, and I am in the unfortunate situation where the gravamen of our petition was public participation, and my lords, my colleagues before me have covered this subject quite deeply. So instead, I will essentially head into the nitty-gritty of what will be provided to you has already been filed in of the exercise of public participation. My lords, as I considered these submissions, I was reminded of a phrase, rather a prayer, from my alma mater, Lenana School. And the prayer says, my lords and my lady, sieve the trash, dear Lord, we ask, for nihil praeter optimum. Nothing but the best. My lords, in regard to public participation, the intentment of the Constitution and of the citizens of Kenya when we promulgated the Constitution was that public participation must follow a process that produces nothing but the best. My lords, in that respect, there is a concept in computer science called GIGO. Essentially what it says is rubbish in, garbage out. GIGO. Also termed as RIRO, rubbish in, rubbish out. This is in regard to processes, and any process, my lords and my lady, that is put, that expects to have.
Did you know that malaria is a top 10 cause of death in Kenya, with over 10,000 Kenyans dying every year from malaria, and the reason being a mosquito? We believe protection and prevention is
output is highly dependent on the quality of the input, the quality of the process itself, and that will determine what the eventual output is going to be. So, my lords, keeping in mind this concept, GIGO, and the expectation pronounced and enunciated in BAT, I will not repeat all these authorities that have been placed before you. The components enunciated in BAT, I would like to now, my lords, walk through each of the documents that will be placed before you. And we start with the Gazette notices that were published on 2nd of October. The Gazette notices were published on 2nd of October, 3rd of October. These are the advertisements. 2nd of October, 3rd of October, 4th of October, and finally, on 5th of October. My lords, this will be, you will find this in the affidavits, in the annexures to the affidavits of Mr. James Njoroge for the second, Mr. Samuel Njoroge for the 2nd and 7th respondents. Now, the first advertisement that was placed on 2nd of October, my lord, there was already an issue without advertisement. Why? Because one of the very first expectation under the components of in BAT is reasonable notice. This advertisement was placed on 2nd, notifying Kenyans that there's going to be public participation 2 days later. When Justice Mwongo on 3rd of October issued his order, he had taken into consideration the fact that 2 days was simply not enough, and he needed and directed that there must be more time given to the Kenyan public. 2 days. But my Lord, looking at that advertisement, what was it actually doing? One, it provided venues, 47 venues. And this is important because what happened after that in regard to the advertisement issued on 3rd and advertisement issued on 4th were all amendments of the advertisement issued on 2nd. Now, already 2 days, 48 hours for public participation. My lords, we have been told, and you will be told by the respondents, that the reason that they decided to take just 2 days for public participation is because the Constitution provided that impeachment of the Deputy President is time-bound. And in regard to that, they will point to Standing Order 64.2, showing that Standing Order 64.2 requires just 7 days, and the exercise must be completed in 7 days, the whole impeachment exercise. And that is the reason they provide participation. But my lords, when you look at Article 145 on timelines, you will note that the timeline, there is no restriction at all on public participation, on the time between the motion being moved and a resolution being passed. The time between a motion being moved and a resolution being passed, no time is limited. Limitation starts from when the resolution has been passed. That is the only time constitutional timelines kick in. So the reasons provided for limiting impeachment to 7 days and therefore curtailing the provisions of Article 10 and Article 118 do not exist in regard to public participation. My lords, as I had previously stated, the second advertisement was put out on 3rd of October 2024. That Gazette notice made one change. It changed the venue for all the Kenyans participating in Nairobi from KICC to Bomas of Kenya. My lord, so what now has happened is that all the residents of Nairobi, based on an advertisement placed on 3rd for public participation on 4th to happen at Bomas of Kenya, have only 1 day. 2 days, my lord and my lady, was already limited. Now we have an advertisement of a different venue, 1 day. If 2 days was bad, 1 day is terrible. Then, my lords, on the same day, the day scheduled for public participation, a gazette and another advertisement was issued. This time, 20 counties, 20 constituencies, pardon me, 20 constituencies had their venues changed. These were constituencies in Bungoma and Meru. 20 constituencies being advertised and the citizens being told, you will undertake public participation today, and these are the 0-day notice, was horrible. In regard, my lords, to the orders issued by Justice Mongo for public participation as a second stage. My lords, the orders of the learned judge were very clear. He stated that he would allow public participation to continue on 4th of October as the first stage, and he ordered that there shall be a second stage of public participation created as a new public participation exercise in keeping with all the components in BAT. Proper notice, not the 2-day notice. Proper information, not the lack of information provided in the Gazette notices. Proper structures, proper access, and most importantly, as a base, proper sensitization. What happened instead, my lords and my lady? On 4th at 10:22 p.m. and at 10:44 p.m., the clerk of the National Assembly drafted a press release
This isn't just any chat, it's ClickUp chat. Sure, you can tag your team, ask questions, and even drop an emoji. But the real magic is how it connects to the rest of my work. I can tag a task, a doc, or a whiteboard, everything I need in one place. This goes both ways. Chats can also be referenced inside tasks to let people join in on the fun. A chat might be connected to a project, so I can see my lists, dashboards, and docs side by side, making it effortless to reference what I need. If my boss hasn't turned his message into a task instantly, this will automatically include the full context and link so no one gets lost. And get this, I don't even have to do it myself. My AI agent can create the task for me if I happen to be away. When chat is connected to the rest of your work, magic happens.
Welcome to another Talking Feds one-on-one. Today we're going to be discussing an important new book, hot off the presses, from one of the nation's most eminent and interesting Supreme Court scholars and a good friend. Melissa Murray is the Frederick I. and Grace Stokes Professor of Law at New York University. She's probably better known to Talking Feds listeners as co-host of the great Strict Scrutiny, the nation's leading podcast on the Supreme Court, which she co-hosts with Kate Shaw and Leah Littman. And now she has just produced really a prodigious work. Thank you for displaying it, Melissa. The U.S. Constitution, a comprehensive and annotated guide for the modern reader. That's us, I think. Melissa,
you are the most modern readers. Yes,
Exactly.
Talking Feds.
There you have it. It sounds a little bit like Gilbert and Sullivan, and that is us. Melissa, thanks so much for being here, and congratulations on a really prodigious achievement.
Thank you. Thanks for doing this. I know that you're feeling a little bit under the weather. I am prepared to do all of the heavy lifting. Don't worry.
That's very kind. And I'm thinking the Fed heads will probably prefer that. But there are things that I really wanted to talk to you about as I went through the book. So I'll do my best. But sorry about my hoarseness. All right. I want to first obviously talk about the book, but then move into how you see the Supreme Court's latest interpretations, internal dramas, and the like. But the book, as advertised, can we see that again, please? Really is a thorough explanation of the entire Constitution and how it shapes our government. We've had, from previous generations, annotated constitutions. Why this book at this moment?
So, Harry, for the last couple of years, I've been doing work with MS Now, formerly MSNBC, obviously a lot of work with the Strict Scrutiny podcast, and talking to people about our government, about the Constitution. Obviously, people have questions right now. There's so many questions like, why do we have National Guardsmen in the streets? Is that something that is constitutional? There are all of these questions. And it occurred to me as I was talking to some of these individuals that we've had a real shift in civic education in our country. So when I was growing up in the 1980s, there was Schoolhouse Rock, and that is how I learned how a bill becomes a law. And also, we had a class called American Government that was required in order to graduate from high school. I think post No Child Left Behind, there has been a reappraisal, a renegotiation of curricular content in most American schools, that many schools are focusing on back to basics courses that are needed to pass certain standardized tests. And civics education, I think, has really taken a toll, has fallen by the wayside in many curricula. And we have a whole generation of Americans who, for no fault of their own, may not have the kind of knowledge of how our government works that they need to in order to be engaged and productive citizens in what was meant to be a government for and by the people.
Yeah, and which it seems to me they really want to be at this moment. These issues come up and they're looking for the kind of constitutional grounding that you give them. And in the preface, Melissa, you write, the safeguards that the Constitution put in place to ensure democratic government may not be adequate in our volatile, politically polarized environment. Kind of a remarkable thing to put in the opening pages of a book whose ultimate purpose is to inspire faith in the Constitution. So
I don't know if it's necessarily to inspire faith in the Constitution, but rather to inspire faith in our ability as a people to be makers of constitutional meaning. I think that's what I would like people to take away from this. Like, the Constitution is what it is. Like, we have the original Constitution, Articles 1 through 7. Then we have an immediate change in the Constitution with the introduction of the Bill of Rights at almost the same time the Constitution is being ratified. So from the start, it's recognized as being imperfect in some way, like inadequate protections for individual rights. And as a condition for ratifying the original Constitution, they are forced to adopt this Bill of Rights. And then we have nearly a century later, another reappraisal with the Reconstruction Amendment. So again, we're constantly in this project of rethinking what this founding charter means, how it works. Some of this is through the amendment process, which I talk about extensively in this book. Some of it is through interpretation, through the courts and the Supreme Court in particular. Some of it is through just the way we live and how our culture impacts the way we understand what is required of the Constitution and how we then put those impulses into meaning. So I think the broader project here is not that we should blindly follow the Constitution, but rather recognize this was always intended to be a document with which the people engaged, and that they were constantly in this project of making the country and this founding charter better.
That's a really fair and important point, and I correct my sort of misstatement, because it's true that the ultimate statement of faith really has to do with the broader dialogue and dynamic among the people, the political institutions, the court for the evolving meaning of the Constitution. You mentioned a little bit in the book Jill Lepore, and her view now is it's no longer a charter that can actually be amended, and that stymies the popular will in a variety of ways. Do you take her thesis? Do you accept it?
Well, so I take Jill's thesis to be that it is incredibly difficult to amend the Constitution. That was always by design. I mean, I think one of the things the framers really wanted to do is that, it was like Ulysses being tied to the mast. Like you couldn't just change because the winds blew a particular way. It was purposely difficult. Now it seems it's almost Herculean to change the Constitution. And that's not just because the Article 5 amendment process is so difficult and challenging. It's also because we live in an incredibly polarized political environment that the framers probably didn't contemplate. I think they talked about factions, but I don't think they understood the way that we would be riven in our political culture as we are today. And so that's one very important question. Like, can we even do this? But then there are these other moments and glimmers of hope. Like, we were also riven, I think, during the Gilded Age. I'm riven by broad inequality in terms of income and wealth. And yet the people came together and said, this isn't right. The way we do these things isn't right. We need an income tax rather than tariffs as a means of revenue generation. I mean, all of this sounds so familiar today, but this was the conversation that they were having at the turn of the century, how to make the rich pay their fair share. They couldn't have a progressive income tax because of Article 1, which had very specific requirements for how Congress levied taxes. They have a constitutional amendment, the 16th Amendment, that makes a progressive income tax possible. I mean, the people, again, at a moment of real political division, real wealth division,